already been done. What we expect the tribunal to do today is to go into substantive hearing of the petition.
But they called it a pre-hearing sitting.
Well, I wonder why they called it so. Maybe journalists may have seen it from that angle, just like I'm telling you now. If I wasn't telling you that the tribunal has already started sitting and has already taken some decisions, perhaps not every Nigerian would have known that. The concern, however, people seem to have is on the entire modus operandi of the tribunal. And the issue you just raised in your intro about the time within which the tribunal should go about its job and the effect it will have on the polity. And I'm sure you would have been referring to section 285, subsection 6 and 7 of the Constitution. And that section talks about giving the first tribunal, which is the Court of Appeal, 180 days within which to conclude its hearing and determination of the appeal, while section 285 subsection 7 now subsequently gives the Supreme Court, which is the final court on this matter, 60 days, 2 months, within which to hear and determine the appeal from the Election Petition Tribunal. Now, many people have misconstrued this to indicate that the tribunal must spend 180 days. If you read that section, nothing in that section says or even suggests that. The only thing that section seems to say is to impress on members of the tribunal the need for expedition, for speed, in view of the sensitive and peculiar nature of election petitions, that they must not exceed 180 days. But there's nothing there that says they must wait for 180 days. No.
And they must use it all up.
Or they must use it all up. Nothing says that these petitions cannot be concluded in 7 days. Nothing also says that the Supreme Court must use up the entire 60 days, 2 months before it decides the appeal. In fact, to underscore the exigency, the Constitution went further in section 285 subsection 8 to say that in order to expedite, nothing warrants even the tribunal to give reasons for its judgment. In other words, the tribunal can simply say, this is our judgment, we'll give you reasons later, just to ensure that this thing is expedited. That's what section 285 subsection 8 says. That underscores it, and that's why most Nigerians, like someone like former president of the NBA, Dr. Olisabakoba, had been clamoring for some radical proactivity by the tribunal, because this petition, the way it is structured, is such that it can, in my opinion, be disposed of in 7 days, maximum 14 days. If you give me time, I'll tell you how it can be done. For example, the candidates have 4 major grounds for their petitions. I'm talking about the 2 major candidates. There may be other candidates, you know, but the Labour Party, the PDP, and their presidential candidates have filed petitions. And, for example, and their petitions are similar. The summary of it, which is they are challenging the declaration of the APC candidate as president-elect on one major ground, that the constitutional requirement for that declaration was not met at all, and therefore INEC ought not to have made that return. They feel very strong about it, whether rightly or wrongly. And they hinge that on section 134, subsection 2, A and B of the Constitution, which says that for you to be declared the president-elect, where there are more than 2 candidates, you must have scored to 25% of 2/3 of the votes in 2/3 of the states of the federation and the Federal Capital Territory. And they said, whatever you scored, if you did not score 25% of votes in the Federal Capital Territory, you should not be declared president-elect. Now, they have their reasons. The other parties feel, no, it doesn't. It's wrong in law. They cited many cases, you know. And the other people too have the argument. They say, how can you say you must get 25% of FCT? If you get 25% of about 30 states, why should FCT be the decider? The other people are saying, no, you must interpret the law the way it is. We lawyers have various modes of interpretation. We have the golden rule, the Judgement generous rule, and all the other rules. But the basic is the literal rule, where the law is literally clear. Don't add anything to it. And the law says you must have 2/3 of, you know, this 25% of 2/3 says, and means conjunction, and means plus, and means including, and means together with. And they now raise the argument that, what if WAEC said, the university said you must get English and maths before you are admitted to read medicine. And you now get 8 other credits, 10 credits, but you lack English, you lack medicine. Would they admit you? The answer is no. So if that's what the law says, that can be decided by the tribunal. It doesn't need 180 days. You can call the lawyers because the result for FCT is on the table. INEC has the certified result. It's online. If this party did not make 25%, come, all councils, come and address us. The tribunal can invite the parties, come and address us one day or 2 hours. Does this lack of 25%, is it fatal or it's not? And after addressing, the tribunal can adjourn to the next day and give its decision and even tell you that I will give you reason later. That's what section 285 sub 8 empowers them to do. Now, if that fails and does not disqualify the APC candidate, you can go to the next one, which is the grounds of the opposition under section 115 of the Electoral Act, which forbids double nomination. Section 115D specifically forbids a candidate from taking nomination forms and filling nomination forms for 2 elective positions. It even went further to criminalize that misadventure in section 115 subsection K, 1K, by saying that the person will even be sentenced to 2 years imprisonment if you are found to have filled 2 nominations. Now, the opposition parties allege that the vice presidential candidate of the APC filled 2 nomination forms for both Senate and vice president. Now, they are saying that that is fatal, considering the clear, unambiguous provisions of section 115 of the Electoral Act. The matter is before the court, so we cannot conclude that this person is right or that person is right. But it is something that the tribunal can ventilate and deal with in 1 day. Address me for 2 hours. The forms are there. Certified true copies can be procured from INEC. Address us that by law, should this candidate be disqualified? Because if the vice president is disqualified, automatically it will affect the presidential candidate, like what happened in Bayelsa, where the deputy governorship candidate was disqualified for incongruities and issues of forgery. Automatically, that was what affected Leon, who was the APC governorship candidate, who was already conducting his parade for swearing in the next day, and the Supreme Court judgment came, and that was it. PDP became the governorship, became in charge of governor of Bayelsa State. That exactly is what will happen, because it's a joint ticket. Once one is affected, it affects the other.
If they go for that.
If they go for that. And that does not require 7 days, because it does not require calling of witnesses. It requires getting the certified true copies and the parties addressing the court on what the law says on that. Now, assuming you scale that second hurdle, there is the third hurdle, the issue of the non-committal forfeiture that will happen in the United States of America for $460,000. Was it fatal? Is it such that falls within the contemplation of our constitution that any person so convicted or so found guilty for anything, money laundering, blah, 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 should not aspire or should not be validly elected as our president? That again is sub judice. I can't stay here now and say this is the correct argument or the other one. But the parties are strongly contesting that that is an issue. If it is so, it doesn't also require you to call witnesses from the 774 local government. No. All you need to do is someone, whoever can give you certified true copy of that judgment, which you're already seeing online, and get the parties to address the court. What is the legal effect of this on the candidacy of the APC? 1 week is enough for that. 1 day for this party, 1 day for that party, 1 day for that party. And the tribunal adjourns for 2 days and delivers